First is minutes of 10/8/25. Need a motion to accept the minutes?
I move that we accept the minutes as amended.
Need a second?
Second.
All in favor?
Aye.
Aye. Need a motion to accept the agenda as is?
So move. Second.
All in favor?
Aye.
First item is Smith, 108 Wesley Ridge, application for single-family dwelling.
I already knocked something over. Good evening, members of the planning board. Thankfully, having a loud inside voice has never been an issue for me, so you should not have trouble hearing me. We are here tonight regarding our application for reapproval of an application that we have graciously received an approval and 2 reapprovals from this board in the past based upon a very thorough record that was developed in 2019. I also note a thorough record that has sustained legal challenge. I understand that since the last time we were here on October 8th, that the board members had the opportunity to visit the site on a very rainy Monday with your consultants.
Excuse me. Would you mind stating your name for the?
Oh, I'm sorry. Yes, I missed that part. Rebecca Volk, Law Office of Rebecca Volk for the applicant. I did receive some information that was submitted to your clerk as of last night, and I'm happy to make some comment on the same. I did submit a letter, albeit at 5 o'clock. I'm happy to summarize that, but I did not know if you wanted to defer to your consultants regarding the site visit before I did that.
John, is there any?
Yes, sir. As was indicated, and I also have a loud inside voice, and that's an outside voice as well. We did make a site visit. It was an overcast day, and the purpose of this site visit was to determine what the actual conditions were on the site. And consistent with the representations made by the applicant in the most current application, there have been no changes to the property. The property, the driveway, and the actual house location remains substantially the same as was observed during the course of the prior visit, which was a couple of years ago, except for the passage of time and the continued vegetation growth and development. The property is fairly well maintained. It's almost at a park-like setting at the top of the hill, and the area that was set aside, the 100 by 150 area that was part of the visual analysis, remains steady. It remains essentially the same character and condition as prior. And it would seem to me that based on my review of the site, and I defer to the planning board members who join me, that the project can be implemented in full compliance with the terms and conditions of the prior resolution of approval. I did include the photographs, so anybody who didn't make the site visit, but we also are. Excuse me. The only thing I would recommend that if when you review a resolution, we would add a condition, and that condition is based on the fact that some time has elapsed since the original approval, and that condition would read prior to the start of house construction or any lot clearing, the applicant shall have a licensed land surveyor confirm the boundary stage for the 100 by 150 foot building envelope and demonstrate the satisfaction of the building inspector that the proposed house and any accessory structures related thereto fall within that building envelope. And that's the results of the visit.
Thank you. Paul?
The main question for the planning board tonight is whether or not you want to, if you have the discretion to waive the need for a public hearing, that has been waived in the past in other approvals of the same project. I would note that there have been some public comments that have been received, have been distributed to the board. Whether or not there's a public hearing, the board will consider them. So the question for the board tonight is whether or not you want to schedule a public hearing for this matter. If you decide that you don't need to hold a public hearing and are disposed of this project, then you will need to provide direction to John and me, provide you with a resolution on November 11th, November 12th. So that's all I've got. There's really nothing, you know, it's a type 2 action under secret because it involves the construction of a single family dwelling. It's been to Dutchess County before. Dutchess County has consistently said this is a local issue of no concern. So it really boils down to whether or not you want to hold a public hearing. And then the question for the board in any resolution will be whether you're willing to waive the 40-foot standard from the top of the ridge line, which you've done in the past. And that's based on all of the visual information that was previously provided. That would be something that you do. Otherwise, the applicant would have to redesign the project.
Anything else?
So I would like to make two comments. I thank council for that presentation. We would submit that it is appropriate to again waive the public hearing as you have done in the past. The comment letters that are coming in are not raising anything new that has not been raised to this board before, and particularly nothing that is different from what was tested by litigation that the town and the applicant succeeded in. So I would note that the particular letter submitted by Ms. Diaz last night includes some photo images where a white square is placed onto the ridge line. That is not in keeping with generally accepted visual practice and is a complete misrepresentation of the project's appearance. In the letter I submitted today, I attached the very thorough photo simulation done by Saratoga Associates in 2019. As noted by your engineer on October 8th, crediting Mr. James, who happened to be in the audience on that date, that placing a home 40 feet below the ridge line would actually result in a greater visual impact because you would be removing more tree cover. This lot has a cleared area that was cleared before the adoption of your scenic protection overlay zone and is the appropriate area for development, as has been found by this board and once again upheld in litigation. The remainder of Ms. Diaz's letter makes allegations regarding personal harm, which again, that theory was tested in the litigation of Neely versus Town of Amenia Planning Board. The court found significantly, first, it is clear that taken together, these provisions of the SPO are concerned with the view of the scenic area at issue from publicly accessible places. So it was rational for the planning board to consider the views of the proposed project from several publicly accessible places and not from the individual private properties of the neighbors. The SPO stated purpose is not to ensure or require that there never be anything visible in scenic areas, except the natural surroundings, but rather that steps be taken to ensure that the character of view sheds in scenic areas not be substantially changed by proposed projects. And in making that finding, the court cited to a July 18th, 2019 email from Mr. James, which found the simulations show tree clearing, but not so much to constitute a significant impact on the ridge line. Finally, the court found that it is clear from the code cited above that the SPO's scenic preservation goals with respect to the construction of a structure less than 40 feet below the crest of a ridge line can be accomplished by imposition of conditions. I remind you that there are a number of conditions on this resolution, including limitation of lighting, the color of the home, the tree clearing area. That's just touching upon a number of them in all of the pages of this decision that this board has adopted multiple times. So So I just conclude my letter. Well, normally I don't like to read a full letter in the record because I submitted it to you late today. I felt it was appropriate to do that for the board. That really all we have is just generalized comment with no expert opinion that's been offered to you. And that is continuing. I am also aware of an email from a Rebecca Thornton simply seeking more time. I would submit that this application has been before this board many times over the years, and there has been sufficient opportunity for comment.
Open for discussion amongst the board members. What did you were at the site? What you see and what your feelings?
Walter and I went to the site with John. We observed the area that's staked out for the proposed building site. It does appear to be set back from the ridge line and obscured from view both from the west, and from the site actually by a row of fairly mature trees. I guess I do have a couple of questions. So John, you mentioned that I know you there you took a bunch of photos. Have those photos been made available on the plan or the site? Other folks can take a look at what we saw?
Madam, I don't know, they were attached to your letter, I read the letter, I see your record, I don't know whether they've been posted to the website or not. But they were part of my letter, and they are in the record.
All right, I think there's value given interest not only from Ms. Diaz's letter arrived, and I didn't have a chance to read it, nor did I have a chance to read your response. I didn't have a chance to read the letter from the DLC requesting additional time that you just referenced. I think that would be helpful. There's also a note in the minutes from 10/8 that suggests, and John, that you suggested an additional visit by the fire department. But I think we talked about it and you guys were already there. Yeah, and so I think that closes that issue. So I have no issue with scheduling a public hearing on it. I think there is value in that given the passage of time and the fact that baseline conditions have changed and there does seem to be interest from the that there has been, I'm not opposed, I'm actually in favor of scheduling a public hearing on this, given the public comment, the fact that baseline conditions have changed, and there seems to be some real interest.
I'd like to just add, after being there, please correct me if I'm wrong, but it appeared actually being on the site that when you're on the site where the stakes are situated, as Nina said, it's further back. The ridge line comes up and then it goes down a little, and the house would be sitting down a little.
That is correct, that's correct.
So the ridge line's there, it's behind the ridge line actually. So I want people to understand that. You would be able to see maybe some lights at night, yes, but I don't think it's that big of a deal, to tell you the truth. But I understand from what Nita's saying, because people concerned we could have a public comment also.
So just for the record, I didn't know Ms. Wall was doing the same thing. But I pulled a photograph, and this is from Sharon Station Road, which would be behind or farther back than the lots that were referenced in the letter. But as you can see, this is the simulation, and you can barely make out the house. And the house is the proper color, proper scale, proper size. And as a consequence, I think Mr. Dietrich's expression of what he observed is truly correct. This is not right out on the point. It is set back. There is a little bit of a rock promontory out there, and there's actually a seating area there that's kind of like right on the crest. But even that you could not see from the surrounding area. That photograph is long behind, or unfortunately, but the original study was done really well. And I just submit that's already in your record. That was part of the set. I just printed it out because I saw the lady's letter, and I wanted to make sure that we had a point of reference. Well, in indicated a white box on an otherwise black background. And this is one that was vetted by Mr. James, part of the official record for this project.
Any other comments?
Yeah, the original, application that was approved, did they do a balloon test?
I can speak to that. The board actually opted not to do the balloon test and immediately asked us to do the photo simulations.
Okay.
When we came in 2019, we had, I believe, a pre-application meeting where that was discussed.
Most of this board wasn't here in 2019.
No,
so
understood.
Please indulge me.
Yeah, no, I'm more than happy to answer that, yeah. That's-
So that simulation that was just passed down is the one from 2019.
I didn't,
That came from the Saratoga Associates Visual Analysis.
Okay, and it's hard to see it, but if there are any, eaves or anything like that above the ridge line, then you wouldn't see those lights. Is there any way we can say, yeah, as long as no lights are above the ridge line, we're fine, but that's I'm sorry, that's another step. So I agree we should have a public hearing. And, I'll make a motion that we have a public hearing.
Second.
I'll second that motion.
All in favor? Motion carried will be.
and when would that be?
When can we do it, Judy?
It'll be the December 10th meeting.
Okay.
I'll send her, 7 Kent Road.
Hi,
Right.
I think you'll be able to hear me too, because when I was in second grade, I got the lead role in the school play for the sole reason that I had a voice to carry. So,
State your name, please.
State your name.
Dave Hawkinson, and I'm proposing a subdivision of our property to sell off a 13.5 acre lot with the historic 1771 farmhouse on it, to facilitate selling it to someone who would take care of and redevelop that farmhouse. So that's the basic ask. I explained this all in our last meeting in August or September, whenever it was. I'm back.
None?
Yes. Thank you, Mr. Chairman. I did submit a letter for the record, basically what we had asked for has been substantially resolved. At that time, there was some glitches in the EAF that needed to be updated. You had that stage was a little off. But as far as I'm concerned, with the most recent bill, the project is ready for a public hearing. And unfortunately, before you can schedule a public hearing, as this is a land subdivision, you have to make a determination of significance on the seeker, and you need to review a part 2, and you need to basically authorize the preparation of a negative declaration. What I would suggest to you is you can schedule a public hearing for your December meeting, and before opening the public hearing, you can complete the secret determination, so long as we spend some time tonight looking at the part 2 impact assessment.
Paul?
I agree with John. I think there don't seem to be any issues that would prevent the board from moving forward with a public hearing. I think the idea of going to the EAF briefly, it's a short form EAF. is probably a good idea. And then if the board is so disposed, giving direction to John and I to prepare secret negative declaration and potentially also an approval resolution, given the minor nature of this project application.
So for discussion of the
Yeah, I
board.
have a question for John. In the letter that you submitted on, that you said one permit.
In terms of the action that you are taking, it's simply a subdivision of land. What happens after that subdivision and after the sale is not part of this action tonight. So that's why it's considered no improvements. But that's it. We realize that he's been upfront about it. He wants to sell the lot because the buyer's interested in preserving and renovating the existing house. But again, this is simply the subdivision of land.
You said there was a,
And Mr. Chair,
Yes?
I did in short go through the short environmental assessment form, part 2, and basically, when you go through this, taking into account this is a simple land subdivision with no intended improvements, all the impacts, items 1 through 12, would be checked no or small to moderate. And I would suggest on that basis that it's in the board's interest to authorize the preparation of the negative declaration.
John, they don't have the SEAF Part 2 in front of them. Do you? Do you have, Ken was trying to find it. Yeah, right, it's for you to, so I would just go through the questions.
Okay, if you wish, I can go through the questions. Okay, will the proposed action create a material conflict with an adopted land use plan or zoning regulations? It's checked no, small, moderate. This is zoning. Will the proposed action result in a change in the use or intensity of the use of land? Here again, it would be no or small. Will the proposed action impair the character or quality of the existing community? Here again, it would be no or small. Will the proposed action have an impact on the environmental characteristics that cause the establishment of a critical environmental area, CEA? This is not in or near any CEA, so yes, it would be no or moderate. Will the proposed action result in an adverse change in the existing level of traffic or affect existing infrastructure for mass transit, biking, or walkway? I would submit to you that the answer is no, moderate, or small. Will the proposed action cause an increase in the use of energy? Fails to incorporate reasonably available energy conservation or renewable energy opportunities? I would submit no or small. Will the proposed action impact existing public, private water supplies? A, or B, public, private wastewater treatment utilities? The lot being created has its own existing well. The lot has its own existing private wastewater treatment facility, so there are no changes there, and it's small, no or small moderate. Will the proposed action impair the character of the quality of important historic, archaeological, architectural resources? This is a no action. Subdivision, so the answer to that would be no. And in fact, the setting remains the same. Most of the acreage that surrounds this house has always surrounded this house. And it's pretty well defined out there. And will the proposed action result in an adverse change in natural resources? For example, wetlands, water bodies, groundwater, air quality, flora, or fauna. Again, it's no action. There's an existing house there. And this action will make a lot of that house to exist. And will the proposed action result in increase in erosion, flooding, or drainage problems? Here again, it's no. And will the proposed action create a hazard to an environmental resource or human health? In a simple land subdivision, house to land, the answer there would be no, small Those are the questions associated with the environmental assessment form part two.
Thank you.
John, how large are the parcels?
I think it's about 13 acres, sir.
That's the total area?
The new lot would be,
13.5.
13.5?
and then the balance is surrounded by mobile farms, so I think the smallest of which is probably 100 and some odd acres.
Okay.
Yeah.
What's your pleasure, ladies and gentlemen?
I'll make a motion.
Favor?
Aye.
So you want to go ahead and schedule, you want to make a motion and schedule the public hearing?
Yes.
And then, you did that?
No, that's next.
Yeah. I'm sorry.
Motion, I'd like to make a motion.
Second.
Do you want to do it on the 11th?
December 10th.
December 10th. All in favor?
Aye.
So carried.
And then, just to add in the meantime, we need to circulate the ag data statement. And Kent Road is a county road, so we need to circulate. Yeah.
Also, I would recommend that, a resolution that it's 2 parcels. I'd like you to have it stipulated the size of both parcels on the resolution. Well, you're suggesting that we draft an approval resolution that includes that? What I'm recommending is that we stipulate what the 2 parcels are. What we're talking about. And then what we're hearing is 13.5 acres, that's the lot
That's the new lot, yeah. And the rest of it is 150 acres.
157.72 acres.
Yeah.
All right, well, thank you. We'll make sure that's in the secret resolution. You all want to approve a resolution draft for consideration? Okay, sure. Yeah.
Yes, just keep resolution when you are.
Thank you.
You're all set. All yours.
Good evening, Mary Lane with Hudson River Housing. Good to be here tonight. We just received today some written comments from Mr. Kapolsky. So I'd like to just make 3 comments on that I can make quickly, but other stuff we need to dive in, and I'm sure in our 308-page submission, the questions are answered, but we'll make sure it's clear where they're answered in our written response. So just the reference, there is no reference in the code about affordable housing, and so the comment was made that we keep going back and forth between affordable and workforce housing. So there is no reference in the code about affordable housing, so we'll just omit the words from any of our submission and make sure it says workforce housing. Mr. Topolsky provided a definition of these 2 terms, but it's from some website. So whoever you ask is going to give you a different.
Website is cited.
Huh?
The website was cited, it was from a publication on the website.
Right.
This is citing it wasn't just full of.
No, I know. But again, I mean, you could go to a lot of different websites. The fact is, this subdivision will be serving people and households under 80% of the area median income. And for the interest of consistency, we will call that workforce housing. The second point is, Mr. Topolsky made a point about HUD funding, and is there a threat of that HUD funding being cut? And if so, would this become a zombie development? But there is no HUD funding in the funding stream for this project. It is all New York State funds that do not have federal funding behind it. So that is not a concern for us. And then there was comments made about 28 lots versus 15 lots that he would prefer to see. And he quoted, I think, town staff saying that the reason we wanted to do 28 lots was because HOH wouldn't make any money on 15 lots, which is not a fair statement at all. That statement was never made by us. It's just all about economies of scale. So we're building a lot of infrastructure here, water, sewer, roads. So it's just basic math. When you look at the total development cost of this project and you divide it by 28 homes, we landed a financial number for the selling price of that house that can be afforded by households under 80% of the area median income. As you chip away at that number, you're just adding tens of thousands of dollars to each house price. So certainly when you get to 15, it's nowhere near affordable for somebody under 80% of the area median income. So again, I just wanted to sway the statement that was made that it was about HRH not being able to make money out of this. It's all about the affordability and the economies of scale. And then
That was not a comment that was quoted from HRH. It was one made by.
you said a town official. right?
Town officials.
So I appreciate that. And then just regarding the fire suppression devices that Sharon Boyles brought up a few times and certainly at the last meeting, while it's not required for single family homes because it is a concern, I just wanted to let you know that we are looking into it. We've reached out to Simplex Modular. Renee gave us a good model for the type of house that we are building here. So we are looking into the pricing of that and see how much it is to see if we can fit it into the plans. So we are definitely addressing that the best we can. So I don't know where we go next.
Yeah, I don't know if the board requires a recap or if they want me to do a quick spiel for the public benefit on this. But in reality, it's exactly what Mary says. We're providing 38 residential lots.
28.
Well, sorry, 28. Whoa, 28 residential lots on 24 acres. They're going to be around a quarter acre per lot. The development as part of a conservation subdivision is required to preserve 50% of the land. We are exceeding that with our current proposal. And I also wanted to note, which I think is important, is that this area was actually studied in depth by the town of Amenia for high density and mixed use residential development. It was part of the Amenia Hamlet plan where they cited actually 28 single-family homes on the property, as well as 7 multifamily units, providing double the amount of units that's currently proposed by the project. Now, I think that's important to note that this is intended for the site. It's why the town studied it, it's why they adopted the plan, it's why they developed this map showing it. So overall, we're not requesting any variances, we're not requesting special treatment. We're requesting a conservation subdivision based off the density calculations the town has provided to us, and we meet that. We're providing public water, we're providing common sewer, and we're providing a scale of residential development that is mirrored by adjacent developments. There's numerous quarter acre to half acre lots directly adjacent to the site. So this is not something that I want to have misconstrued that is being blown out of scale. This is something that is intended for this site, encouraged by the town of Amenia, and compliant with the zoning provisions. Otherwise, I'm just happy that we've had a chance to submit this document and the board has had a chance to review it, and happy to write down any comments. I know that the big part of this, we have to go through seeker and declare an action. I believe a big part of this is receiving public feedback. And so our objective is to progress this as quickly as possible to the public hearing stage so that we can get that feedback, review it, and try to address the concerns the best as possibly we can. So again, thank you, board, and happy to answer any questions you may have.
Mr. Chair, I did submit an email to the board members. Basically, I just want to remind you, at the meeting on September 25th, I did go through my comments. I sent you a written list of what those comments were. And I think what's really important here is, while there are issues to be developed, most of those issues are subdivision related and would come through that process. And what basically the applicant has submitted what I believe to be a complete preliminary application and a complete environmental assessment form with a rather substantial background. And the information contained in that project summary and impact assessment is substantial. And in our review of it, we did not identify any items likely to result in significant adverse environmental impacts. You need the next step here would be basically the board to review a full environmental assessment form part 2 and go through and decide where you want to go with this. And I believe if one pulls apart the record, which I've done on this rather voluminous document, I think most of your questions have been answered. I'm going to make a few examples. Mr. Kowalski had raised some issues with respect to groundwater. Groundwater is a very clear thing, but to the point that Mr. Sanders made in his documents, they did conduct a series of actual deep hole observation tests to evaluate where groundwater and rock were in areas of septic and in areas of possible stormwater management. But not only did they do it, WSP, their hydrogeologists, conducted test holes in different locations. And between the two of them, they do a fairly comprehensive job of identifying where groundwater falls, and it varies throughout the site. They do a fairly comprehensive job of demonstrating where modeling may be, in other words, where that water table may rise or fall to and from over seasonal differences. And in fact, WSP does a seasonal evaluation of the overall groundwater. So that's more information than we typically have on the subdivision. So it exists in the record. They did do a traffic impact study. Traffic impact study, unfortunately, in the eyes of seeker, if you don't reach 100 cars, you're not considered a significant impact. They kind of top out at about 28 cars. The other issue was made and discussed it a couple times is the potential for pedestrian circulation. The site is directly across the street in large respect of Fresno. And one would say, small lot, small community, what are you doing for pedestrians? Well, the interesting thing is, if you look at an aerial photograph of the Fresno site, which I did, there is no landing spot on their sidewalks. So we could do a wonderful job of putting sidewalks on the side where this project is, but there's no potential for crossing and there's no sidewalks currently on the other side. That's not to say you shouldn't be considering it. Just making your point that in the record, they've addressed most of those issues. And, they did for instance, they did an archaeological evaluation, part 1, phases A and B, which is not necessary. They've done a fairly extensive agricultural response regarding soils. The last thing here is a lot of concerns have been raised about stormwater and impacts on the creek. The interesting thing with this project is the total overall disturbance really exceeds 1 acre. By exceeding 1 acre, it is therefore covered under the New York State general permit for construction activities. By exceeding 1 acre and being a subdivision such as this, they are required to address not only water quality concerns, but water quantity concerns, including the 10 and 100-year storm and other things. So in order to pass go and collect $200, they have to address all those things, and they have to meet a series of standards. They have submitted documentation in terms of actual field testing and preliminary sizing to demonstrate that they can accommodate those using specified techniques within their project site and within their design. From my standpoint as the engineer, there is not much else I can say. It now falls to you folks about where you want to head and what you want to do.
Not a question.
Yes, sir.
Look at some notes from prior meetings. Is it correct that the density that is proposed is dependent on environmental focuses and preservation of land?
If I remember correctly, your code has density provisions. They're relying solely on the workforce housing density bonus. But in order to get to this subdivision, yes, they have to preserve, as Mr.
And are there still utilities inside the land considered?
There are utilities inside the land being preserved, but if you read your code, that is a permitted use so long as they do not negatively impact the reasons for preservation. And they kind of demonstrated that. Most of it's going to be subsurface, some of it's going to be a community garden. They did subtract a small area for the water building and the commercial parking related there too. So they did try to do that, but
could you circulate the point us to the code for that? Because I still feel concerned considering talking about this. Not that.
yeah, I can do that. Yes, sir. I know that's why
Because you had septic in the preserve plan, right?
Correct. And
these trucks will need to roll through that septic.
so the way we have it is that all above ground structures, and so in that event, actually for that one, you're worried about septic pumping. That's not going to be a concern on this because each individual residence will be provided its own septic tank. So theoretically, the subsurface system will not need to be maintained on a regular basis or really ever until the point that that system may fail. Each house will have that residential tank and that's where the pumping will occur. So a pump truck will come in and empty the septic tank out from these residential lots.
At some point in the life out of septic.
That's the whole point of the 100% reserve system. In that scenario, the primary system would be abandoned and gotten rid of. And then that place will then return to open fields and agricultural land, open space. And then the area with the reserve system will then be turned into the septic system. Again, installed with the septic sewage disposal system, stabilized and replanted with seed. So again, if that does occur, and again, the lifespan of a septic system, John may be more familiar with this, but I believe it's around 50 years minimum. And I've seen septic systems that have been from the 1900s. So again, that's just a standard. So for the concerns of pumping and trucks within the conservation easement areas, I would say there is none.
I just like to see it, I struggle a little bit with the nature of nuclear utility. Faults in there.
Yeah. So, and this actually has been addressed with we did this with the Troutbeck development, where the board determined that the scenic open space field was the area that needed to be preserved. We included that in conservation area, but we've also cited all of the site's septic systems in that field. So again, this is very commonplace, at least within the code and how it is written, because it really depends on what the board values as what is the most conservation-oriented part of the site.
Might I just ask, though, this has already been approved, the conservation analysis, correct?
There are two different things there. The conservation analysis was approved as to what needs to be preserved. Moving on to the design of the development, and Mr. Video's point, right now, within the confines of your area set aside, you have subsurface wastewater treatment systems. You have 2 individual wells right now, and you have stormwater management facilities. There's collection pipes that will run through certain easements, and then you have a stormwater management facility, design of which has not been yet completed, but that will need to have some easements and access to it. In terms of the structure for the water facility and the underground tanks, they kind of pull those out to a corner, and effectively, if you look at their documents, it's not part of the conserved area, but it's included within the conserved lot. So for the most part, the only above ground stuff you will see are the wellheads and probably, I think it's off the road, runs down the side and then turns. So, and then you'll have, right now they're proposing a bio-retention area of sorts, which will be basically a well-vegetated and planted meadow that will occasionally accept stormwater and then dissipate. So it's actually, in most places, if they're done right, planted correctly, and consulted and enhanced. Not a detriment.
Yeah, and just to note, one of the things that the board decided was the most conservation important aspect of this was that stream corridor. We actually shifted the whole subdivision design from being based around the stream corridor to pushing it away, providing a huge green space buffer that, again, will have stormwater management practices that may actually help with the current conditions of that creek. So I just wanted to point that out.
Okay, so procedurally where you are is you've done the conservation analysis, major conservation findings. The next step that you need to take is really to get to a secret. You can't set a public hearing for the subdivision under New York state law until you've made your secret determination. So, you talked a little bit about some of the secret issues. John spoke to those. On November 12th, we circulated the board's intention to be a lead agency for secret to all the other agencies. On November 12th, you'll be in a position to establish yourself as secret lead agency. At that point in time, you will also be in a position to make your secret. So what John and I have recommended is that the board really kind of focus in on the seeker issues, what all the information that the applicant has provided, and whether or not there is additional information that the board believes is necessary for it to make a secret determination. As identified some discussion points on seeker, there's also the potential identified of impact community services in terms of fire department capacity, and I'm not sure if we've seen anything from the fire department yet, but I think that's something that is probably really important. Member Polsky also raised the question of potential downstream impacts to dog turtle habitat, because apparently there's dog turtle habitat several hundred feet downstream. I'm not sure that that was addressed in the wildlife study that was done, but it may be something that needs to be pointed out, cleaned up a little bit in terms of the relationship between stormwater coming off the site as controlled by the SWIP and how that might affect downstream dog habitat. That's another issue. The board can have a conversation tonight about any other secret type issues that need some additional information, and that would give the applicant the opportunity to perhaps respond now or to provide some of that information for the November 12th meeting. The other things that the board can do tonight, one would be to release John's comments and my comments on John's comments to the applicant so that they can review them and see what we have said, if the board is in agreement with those comments. Then also, and this goes to the whole workforce housing, affordable housing question, you have a responsibility under the zoning law to refer the application to the workforce housing board. Since, and if you agree, that the preliminary application is essentially complete technically, it would be an appropriate time for wants to make that referral. And that might provide some clarity on Mr. Wilson's question. The other thing you can do tonight is refer this application to Dutchess County Planning Department for its advisory comments. Because once you have what is essentially a complete application, that would be a full statement for purposes of General Municipal Law 239 and review. So those would be the three recommendations for the board's consideration tonight.
Open for discussion amongst the board.
Just wanted to, John, for the comment about the lack of pedestrian landing infrastructure at Freshtown, I think the same hamlet plan that Peter talked about that recommended some additional development on this site also recommended additional pedestrian infrastructure. I think it's been on the town's kind of top of the town's list for a pretty long time to provide sidewalks along 22 or somehow prioritize that kind of pedestrian access to Freshtown. So I think, there is value in having residential developments, particularly those that are so proximate to the full Freshtown Plaza. Consider putting in pedestrian infrastructure so that if at some point in the future, we are able to get some more sidewalk connections throughout town, that they exist, right? I'm not generally in favor of creating sidewalks in a vacuum, but this is something that's been talked about, contemplated. You see there's some implementation along the road 44 as opposed to Beacon Park. So, if there's an opportunity there as part of your traffic study or your coordination with DOT, to take a look at the opportunity to do that, to create additional safety in the crossing area across from Freshtown. I think, it behooves you to kind of think about that and figure out whether or not there's an opportunity.
My comments were not meant to dissuade you. My comments were simply that it's been a concern. I would echo that. There are a lot of places where there's certainly argument sidewalks in nowhere, and all of a sudden those sidewalks can be used in fashion. So there are different ways to handle it, but that is really a call for the board. I can only point you to the facts and circumstances around it. So somebody has to be first, and so these are the things say no. It's just the fact that you may want to consider, even if it's nothing more than an easement now, that comes to the town that will allow construction if and when sidewalks became available at present. So it's up to you folks. But I would again try to follow Paul's direction. Forward.
Any other comment from the board? Seeing none, we go to Paul's recommendations. Move forward.
So the first one was to authorize the consultant comments to be distributed to the applicant.
Motion of that.
Make the motion.
All in favor? Aye. So carried.
Second, to authorize referral of the application to the Workforce Housing Board.
Amelia Housing Board. That's what they're called.
I stand corrected, I'm so sorry. Meeting Housing Board.
So motion. Second.
I second.
All in favor? Aye.
And then third, authorize referral to the Dutchess County Planning Department. GML 239M review.
Motion,
Make that motion.
second. Second. All in favor?
Can I just ask, when will those referrals take place? And when will we get the comments? And when will these referrals take place? And how long do they have to comment?
Judy and I will work on the referrals tomorrow. That, and then on the comments, you have those, and you can probably just work on tomorrow as well.
Great.
Probably not gonna happen tonight.
I know you've had a long day. You were on a plane to New York City, then back up here. Crazy. What else was I gonna ask?
You got any comments?
So no comments on these secret questions, or comments are coming? We should just look at the things you mentioned and respond? Okay.
Right, you guys are authorizing a letter that you've written for, in review of our application.
They're just a listing of comments.
Perfect.
Okay.
Yeah, that's perfect.
I'm sorry, I just have to add, forgive my,
Right.
it's been a very busy time right now, and I can't remember offhand if we have the FEA Part 1 or 2.
You have the FAF Part 1,
We have Part 1.
plus their own environmental assessment.
Right, that I-
Traffic studies, and habitat studies, and all of that. So, thanks for the opening. I would suggest for the board for November 12th, we'll be asking the board to establish itself as lead agency. And if the board can be prepared, if there are additional secret issues or secret questions that would like answered, to be able to present them so that shortly thereafter, we can go through the Part 2.
We would love to see a determination next month, because again, we've been since last December trying to get to public comments, and we really want to hear those so we can respond
At
to
that
those.
point, too, the board can consider setting a public hearing.
Great, thank you very much.
And just a quick question, for those comments, would you want a response prior to the November 12th meeting? Or is this something maybe we should either wait for a full submission until we get a public comment round? Because I'm assuming based off.
Some of them you'll be able to determine when you see what my comments are, not major.
Okay.
So, to the extent that you can add clarity in any of the issues, please add clarity before that meeting, so before that's.
That's the board, we should give us a better idea.
Yep, that works. Thank you.
Thank you.
Secret.
Yeah, I gotcha.
Okay, go ahead.
Just a couple of questions before the public hearing. Sorry, scoping session. Last meeting, we talked about, Paul, you were gonna put together a whole package for Northern Red Oak Trail and circulate it to the board before it was forwarded.
That is not
That's
happening.
not happening, okay, cool.
Nope, nope.
All right,
That reminds-
sure, we're canceling the 26th and December 24th? Okay.
Nina, just on that, I reached out to Ian, and he's been away, so, that's part of it. I just want to make sure that we're on the same page. Over to you all, and then send along to him.
Okay, so, but we're getting a look at the full package before it gets sent to the
Absolutely,
town
and in
board.
the meantime, in the conversation, I talked with the attorney for Northern Red Oak, and they are, working to satisfy John's questions, because nothing really happens until there's basically a complete application there.
Then, Cascade Mountain Lands, what's the status of that, anyone?
Cascade Mountain Land, they have submitted a final subdivision plat that complies with all their requirements. We're waiting for comments back from council on an easement, but they are ready for final signature if and when we get the call.
Okay.
We'll have to-
And then just a rundown of November 12th meeting is Randall's Road, there's a public hearing. Cumberland Farms, there's the digital submittal was received. Tyler Ridge Condo and Silent, and then the 2 or 3 matters that were mentioned.
That's too much for one.
Well,
And Randall's Road. That's a lot.
We'll be fine.
So Fox Hollow, Cascade Creek, what else, Judy?
Eastside.
He said back on for the 12th?
No, I had it on there. Yeah.
What's on, he said it's back on for November 12th? Okay,
So,
all right, so that's 1, 2, 3, 4, 5, 6, 7, 8, 9 matters for the.
Is it inside?
Yeah,
Inside.
on the list. All right. Maybe I'll miss it.
And what's interesting. And John, someone together for us? Okay.
You mean like a process?
Yeah, the process is, John.
That's weird.
All right, I recuse.
Okay. Next on the agenda is discuss 27 lot subdivision, hold up 22, public scope. Public hearing, public scope, no, we'll have Paul give open remarks to this.
Thank you all. For the public and for the board, I gotta start by saying what this is not. This is not a public hearing on the Keen Stud project. This is a public scoping session for seeker review purposes. Okay, that is part of the seeker process, because the planning board, after reviewing the voluminous information the applicant has provided over the past several years, doing a conservation analysis, making conservation findings, and really going back and forth, primarily on visual impact issues. The board decided that it was going to require an environmental impact statement for the Keen Stud project. And as part of that, the board identified, because they only had to identify one issue, they identified 3 issues that they thought were significant enough that they needed to be studied further in environmental impact, in-depth environmental impact statement process. So those issues are the visual impacts. They're also the consistency of the project with community plans. Finally, there's the consistency of the project with community care. Those are the issues that your planning board has identified that need to be studied in depth in environmental impact statement. So what has happened, as required by the secret regulations, is a draft scope has been prepared. The scope is on the website. Notice was provided to properties within 500 feet of the Keen Stud property. Notice was provided on the town's website. Notice was provided to all of the agencies that have any interest in this project. And the notice said basically on October 22nd, there will be what is called a scoping session on the Keen Stud project, on the draft scope. purpose of the scoping session, primary purposes, are to identify or to get public comment on impacts that should be considered in the environmental impacts. And as I said, the planning board's already identified 3 of those. It's also to get public comment on how those impacts ought to be studied. And a lot of what's happened between the applicant and the planning board over the last several months, including the planning board's visual consultant, has been focused on that, trying to come up with something that, because the project involves the potential residential build out of 23 lots. 23 lots with residential development out of the 600 plus acres that are involved in the project. And so what the planning board really wanted to do is, well, what's realistically potentially going to be built on those lots? Is it going to be small little farmhouses or potentially bigger houses, much bigger houses, more like what's in the side of the ridge somewhere? So that back and forth has occurred, and you'll see in the draft scope, there's actually a lot by lot breakdown of what is potentially going to be built on each of those lots. And so what the visual impact study will do is, and we have to explain this in further detail, but it'll look at all of that, and then make simulations of it. So what you will see in the environmental impact statement, once it's done, is what the project may actually look like if it is fully built out. And that's for the purposes of assessing the environmental impact. So what the input that the board is seeking tonight is really on whether they've identified the right impacts that need to be studied further in the environmental impact statement. Because there are some impacts, as you'll see as you go through the scope, that they said, yeah, there's going to be impacts, but they don't rise to the level of significance based on the review of all the information that the applicant has provided, which is also available on the website for the public to review. So, the public comment really is focused on, are there any other impacts? Or with respect to the impacts the planning board has identified, visual, community character, community plans, are there other things that ought to be studied as part of the environmental impact statement process? The last thing is, in the draft scope, the applicant has provided some alternatives that it would also look at as part of the environmental impact statement process. The planning board's consultants have identified, the visual consultant, along with me, have identified some additional alternatives that it believes that legally ought to be studied. That's been planning board's consideration as well. So all in all, this is not a public hearing on the project. It is not, it is really much more focused than that on the environmental impacts and what the draft scope will be, what the scope will be that the applicant has to study in terms of the impacts of this project. I hope that's helpful to everybody. Because there will be, after the final scope is done, the applicant will go into a draft environmental impact statement. When that document is ready and complete enough for the planning board's opinion for public review, then there will be a full public hearing, not only on the environmental impact statement, but also on the subdivision itself. Okay, so there will be ample opportunity for public participation and comment relative to the whole project. But that'll be several months from now, unless these guys work way faster than anybody would normally do. So I wanted to share that with you. The other thing that the board would like to do is to, the notice indicated that public comment would be accepted until October 22nd, which is tonight, in order to give those in the public who have not had an opportunity to look at this scope a little bit more time. The planning board would extend the opportunity for written comments until next Wednesday, October 29th. And then after that, the applicant will have a week to respond to the public comments that have been made. And by November 12th, the planning board is required under the secret regulations to adopt a final scope for the environmental impact statement. So that's the goal that the board is aiming for. That is adoption of a final scope on November 12th. So there will be further opportunities for public hearing. Tonight's opportunity is much more narrowly focused, and we look forward, I looks forward to hearing the input that the public has. Yes, sir.
Go ahead.
Thank you very much.
Well,
I guess I didn't need that to say my name. My name is Peter Farrow. I'm a planner with the planning and environmental consulting firm AKRF. And I am working on behalf of the applicant and will be the one responsible for preparing the draft environmental impact statement, drawing on the large amount of work that was done by the other Peter on the team, or I guess I'm the other Peter, but the large amount of work that was done by Peter Sanders. So I just want to give a couple minutes of an overview on what the project is that's being proposed, and then sit down and listen to comments. I appreciate that. So I'm going to go quickly over just some rough outline on the project site, a description of what the project is, what that action before the planning board is, how that action is going to be studied in the SECRA process, which is the State Environmental Quality Review Act process, and then go on and add a little bit more depth to how those impacts that were identified by the planning board are proposed to be studied in the DEIS. So first, the project site, it's approximately 605 acres. It's located off Depot Hill Road and Old Route 22, and I apologize, I didn't get the county route on there, but it's that 81. Thank you. I couldn't remember from last meeting. The site is currently used for various equestrian facilities, hence the name Keene Stud. It's also used for row crops, and then significant portions, especially on the east of the site, are forested or filled with brush vegetation. Surrounding the site are agricultural uses, low-density residential uses. Demenia Hamlet's immediately to the north of the site, and off-page left is Silo Ridge. So just to give a comparison of the relative size of the site, and we'll go into more detail in the EIS, but the overall size of the site, again, 605 acres. And before I get to what's being proposed, this is just a breakdown of where those uses occur. The yellow are row crops, the lighter green are the equestrian paddock uses, the darker green are the forested areas, and there are also existing farm roads within the site, which will actually be reused for this subdivision. The map on the left shows areas of steep slopes. The darker the color, the steeper the slope. So if you kind of get this image in your mind, you'll see this as we progress through what the actual subdivision plans are and how it was laid out. But obviously you can see the steeper sloping areas are to the east, and those are largely the forested areas. So the majority of the site is zoned rural agriculture, RA. That's the green on this map. Comes with a minimum lot size of 10 acres. The balance of the site in the yellow is zoned rural residential. So as was presented to the planning board in various conservation analyses, which will kind of go over that history, not the details, I promise, but the history. A conventional subdivision on this property could yield about 42 lots. Conservation subdivision could probably yield about 82 lots, with some bonuses that are in the code, potentially up to 135. That is not what's being proposed. The majority of the site is also within the Resort Development Overlay District, obviously, which allows other uses on the site. So performing arts centers, spas, wellness, and a host of other uses at greater densities is also permitted. And finally, the majority of the site within this dark green area is within the Scenic Protection Overlay District. And one of the important things to note about that district, as was the case with the first application tonight, construction of houses within that Scenic Protection Overlay District, even a single family home, requires approval, site plan approval from this board. So what is actually being proposed? So the proposal is for a 27 lot subdivision on the 605 acres. Two of those lots, the easternmost lots, are proposed to remain forest and in conservation. They would not be developed. There would be deed restrictions attached to those lots, conserving them. Two of the lots in the center of the site, in the light green, that doesn't show up very well on the screen apparently, would be for the existing equestrian uses that would remain on the site. So those would be the main equestrian barn, the main paddock area. Those would remain on the site. So that's 4 out of the 27. The remaining 23 lots would be subdivided off for residential agricultural use pursuant to the zoning. The subdivision would also construct 3 roads or rural lanes, and these would largely, if not almost completely, follow the existing farm roads on the site. So it's not about grading out new roads. It's about making those farm roads usable for this subdivision. As we'll get to in a little while, the end result of this process over the past several years with the board is that the application currently in front of the planning board, in addition to this 27 lot subdivision, are a series of declarations and easements that would result in over 90% of the site being preserved as protected open space or farm uses and not for residential development. There are no buildings being constructed as part of this application. This is a subdivision application only. However, for the purposes of considering the environmental impacts of the subdivision pursuant to seeker, we are considering, as the board rightly required, a full build out of what could be built on this site in the future. And that way the board and the public can evaluate the potential build out of this site, even though no buildings are currently being proposed. So how did we come up, or how was the design developed? So it was basically thought of as this low density farm use that fits in with the existing character of the land to the maximum extent that it could be done. So first and foremost, it was to avoid sensitive lands, right? Avoid the forests, avoid the wetlands, avoid the steep slopes, avoid the hedgerows, and we'll talk about this in a little bit, but actually make use of those hedgerows for siting of the residential uses to minimize their visibility. And then reduce the amount of development smack dab in the middle of an open field, or reduce the amount of residential development. The principles that were used to kind of site these residential landing areas really are these principles of kind of these rural siting principles adopted in the code, the Greenway principles, minimizing clearing, preserving natural features, reusing the existing rural lanes, and putting the buildings and access roads at the tree lines. And it's a little difficult to see. I'm going to attempt, if I can figure out which one is the laser pointer. I'll never figure it out. Is it this one? Laser pointer. For the given lot, and we'll go into this in a little bit, if we just take this lot, for example, this is the overall lot line, there's a larger rectangle inside this lot line that indicates the area within which residential development has to be limited. So residential development has to be limited within that larger rectangle area. This smaller rectangle area indicates the size, the maximum size that residential development could take. So the larger area says all residential development needs to be within this area. That smaller rectangle says, okay, within that big area where you can put that residential development, this is the maximum size that residential development could take. And when we talk about residential development, I'm not talking about a building footprint of a house. I'm talking about the accessories that would go with it, a pool, patios, etc. So that's a little bit that. Now I guess I have to turn this off. And then really the goal here, unlike other subdivisions, that have been before the town, right, is to kind of continue to promote agriculture and tourism in the rural character. So instead of building the 42, 82, 135 lots and houses, to preserve that rural character to the extent that we can. And so if we look at the comprehensive plan and the relative and the principles laid out in the comprehensive plan, the plan talks about balancing between rural, historic agricultural uses and smart economic growth and development, recognizing that no change is simply not an option in many places. It also talks about the comprehensive plan about agriculture as a profitable business and preserving open space, and to kind of build on those strengths. And the applicant believes, it's their opinion, that this design, this subdivision is in keeping with those principles. So a little bit about the application process. Back in 2021, the applicant made their initial submission. There was a sketch plan application that led to the conservation analysis that's required under your code. That analysis took approximately, it was over 2 calendar years. During that analysis, that book that was presented for Cascade that everyone has on their desk, there was a book a little bit bigger than that provided on this application with technical analyses on wetlands and waterways, habitat, protected species, a significant archaeological study that included documentary research and actual, what they call phase 1B testing, shovel testing, where they actually went out and looked for artifacts, an analysis of visual and scenic resources. And then for all of those analyses, there was a study of several different alternatives. And so each of those alternatives were looked at for those different categories. The result was in 2023, the planning board adopted conservation findings. Those findings stated that a conservation subdivision is not required for this project, and it identified the areas of the site with the highest conservation value. So that would be they were identified as the Keen Stud Equestrian Facility in the middle here of the site, the need to protect through deed restrictions, open space and agricultural areas, the need to protect wetlands, water bodies and their habitat, and the forest preservation. At that time, this is the old subdivision map that was proposed at that time. At that time, 73% of the site was proposed to be protected from residential development. And finally, the conservation findings stated that areas within the Scenic Protection Overlay District, which, as you saw, is a good chunk of the site, most of the site, were identified as having potential visual impacts from the eventual construction of any new houses that could occur after the subdivision. So after 2023, the applicant engaged with the planning board through an iterative process. Additional visual analyses were performed. The methodologies changed and evolved to kind of refine those analyses and really get at the concerns. And you might not have noticed, but the current proposal actually reduced the project size. It removed the northeasternmost lots from the project. And I'll get to that in a second. And then finally, there were several other project modifications that were made. So the first is, if you remember the old map, there were parcels up in this area in the northeast were proposed to be included. Those were removed from the site. Obviously, there are waters and wetlands up there. There are federally easements benefiting the federal government for habitat protection, and those were just removed from the site to protect those areas. In addition, the layout of the lots was changed in several different places. In addition to the layout being changed, the area of residential development that was allowed, that bigger rectangle within the lot, was shrunk, and that smaller rectangle was shrunk. And in addition, the places where those residential development could occur were shifted on these lots. So they really were sited to the extent that was possible along these hedgerows. And so they really are, instead of smack dab in the middle of a field, right, they're at the edge to minimize those visual impacts. And you'll see it kind of throughout the site. As a result of these modifications, 90% of the site would now be deed restricted and protected from residential development in perpetuity. And that was an increase from 73%. In addition, recognizing that this northwesternmost field area is one of the most sensitive visual resources on the site, the applicant established these other kind of shaded zones here. And these shaded zones would be deed restricted for no vertical development at all. So no agricultural structures, no barns, no nothing within these sites to ensure that, in addition to kind of reducing the residential footprint, that the overall open space look and feel of this field, which is quite prominently viewed, would be maintained. As I mentioned, the reduced residential footprint was established. In addition, the applicant proposed to reduce the maximum house size. So instead of putting on the maximum house that was permitted under zoning, the applicant agreed to limit that maximum house size so you wouldn't have 20,000, 30,000 square foot houses, because these are quite large lots, and really reduced them and kind of made that fit in. They also reduced the maximum height of each house. So currently the code permits 35 feet. The applicant agreed to reduce it to 28 feet to really, again, reduce those visual impacts. And then finally, they proposed a series of design guidelines, including color guidelines, and color standards that would be deed restricted, again, that would, again, help to minimize the visual impact. And the applicant worked with the board and the board's consultant to develop those. And again, all of those would be included, all of those restrictions, in the declaration of covenants and restrictions that run with the land. So where are we today? As Paul said, September of this year, the planning board required the applicant to prepare a draft environmental impact statement. And further, as Paul said, the purpose of the DEIS is to analyze the project's potential significant adverse environmental impacts and identify measures to avoid, minimize, or mitigate those impacts to the maximum extent practicable, including through the analysis of alternatives. So the planning board identified the 3 impacts that Paul identified earlier: potential visual and aesthetic impacts, consistency with community plans, and consistency with community character. So this is one of my favorite charts. I haven't been able to animate it very well, but let's just, it works actually row by row really well. So where are we in this EIS process? We're at the very beginning. So the board, upon determining that the applicant needed to prepare a DEIS, circulated this draft scope. It is published on the website, along with numerous other studies that have been submitted to the board and comment and certain letters from the board as well. Tonight, we're here to hear your comments on that draft scope. Does it cover the issues that need to be covered? Is it addressing those issues in the way in which they need to be addressed? Planning board hears those comments, they issue their final scope. And that becomes the table of contents that's handed to the applicant and says, this is what you have to go do. The applicant prepares the preliminary DEIS, and everyone's favorite time in the seeker process is here, where that preliminary DEIS goes back and forth between the planning board and the lead agency to make sure that the applicant, between the applicant and the lead agency, to make sure the applicant covered everything that's in that table of contents. And revisions are often required to make sure that everything is in there. When the lead agency is satisfied that the document's complete, not that they love it, not that they agree with it, but that it's complete, they make it public. And then there is a public hearing. And that public hearing will be on the draft environmental impact statement. And as seeker encourages strongly, it will also be on the subdivision itself. So it'll be a combined hearing. Once those public comments are received, the lead agency prepares what's called a final environmental impact statement, or FEIS. The FEIS is required to include a response to every substantive comment that is received. Once that FEIS is complete, the board now has what's called a complete environmental record. With that record, they make what's called a finding statement. That's their decision document. That's where they say, this is what we found based on this environmental record. These are the impacts that were identified. These are the mitigations that were analyzed. And this is what we are going to require. And this is the basis on which we're going to make our eventual decision on a subdivision application. So what are we proposing in the DEIS? So a study of those 3 topics that Paul put forth earlier. So to look at the visual and aesthetic impacts of the project. So the DEIS scope calls for photo simulations of the full potential build out of the subdivision from 18 different vantage points. Each of those photo simulations would compare before current and after conditions. Those after conditions are based on, it's like a New York City term, but we call it the reasonable worst case development scenario. It sounds worse in New York City, but it's based on this, what could happen? What is the maximum build out? And we worked with the applicant, worked with the planning board and its consultant to develop what is reasonable to be developed on each of these lots. Not what will be developed on each of those lots, because there is no proposal for development on those lots right now. But what is reasonable to assume? What could have the most visual impacts? So that will be looked at. And then there'll be an evaluation of community plans and community character, looking at the land uses on the site and off the site, how those land uses would be compatible with the subdivision as proposed, or how the subdivision as proposed would be compatible with those land uses, excuse me. Looking at impacts to prime farmland soils, and then numerous different public policies. So the town comprehensive plan, the Greenway plan, the Dutchess County Ag Farmland Plan, natural resources inventory, and you can kind of read them all there. And so we're trying to analyze the consistency of this subdivision with those policies. One of the other key points in a DEIS is the study of alternatives. So SEQR requires a description and evaluation of a range of reasonable alternatives to the project that are feasible, considering the objectives and capabilities of the applicant. So it's not the purpose to look at everything under the sun. It's to look at alternatives primarily for the purpose of investigating means to avoid or mitigate impacts from the project that's proposed. But it's important to note, and we will note this in the EIS, but I want to note it tonight as well, the project that's before the planning board right now was not the first project that came, the iteration of the project that came in. The project has already been modified in its size, in its scope, and in the details of the potential development that could be permitted on the site. So when thinking about alternatives, there will be a range of alternative study. We're going to go into those in a second. It's important to note that this project was not day one. SEQR kind of contemplates that this was a day one project that's being studied. This is not a day one project. This is a year 4 or 5 project that has evolved already in an attempt to mitigate impacts. Nonetheless, the scope identifies 4 alternatives that were one of which is required by SEQR, the no action alternative, what if nothing happens. The other 3 were suggested by the applicant, and the Paul and the board's visual consultant, George James, offered 2 additional alternatives that they recommended be studied as well, including the clustered conservation subdivision and a resort overlay alternative to evaluate the potential to reduce those impacts. And as we said at the last meeting, the applicant has no objection to those being included in the scope, which, by the way, doesn't matter that much. We're not writing the final scope. They are. Nonetheless, we don't have any objection. Importantly, the scope also contains a listing and explanation of topics that were considered by the planning board. The impacts were evaluated by the planning board over the past 4 years and were the subject of numerous studies, but were considered by the planning board not to have the potential to result in a significant adverse impact. Again, we're talking about 27 lot subdivision, 23 of which would have the potential to be developed. So these are the issues that the planning board said based on our review of the record, and that record is on the website. I encourage you to check it out. You can download the information that the planning board has and had. The planning board preliminarily said these are the topics that we don't believe need further study because they've already been studied quite extensively, and we don't believe there are significant adverse impacts. So that, impacts to land, surface water, groundwater, plants and animals, cultural resources, agricultural resources, transportation, energy, noise, odor, light. So these are topics that sometimes are covered in EISs, but again, we're the subject of a significant amount of analysis. So with that, I will end. We are at the beginning of the SEQR process. Look forward to hearing comments and look forward to the scope being adopted on the 12th so we can prepare the document and get it out for public review and the actual public hearing. So thank you very much for your time. I could. She asked if I could leave the map of the proposed subdivision on the screen, and if that's okay with the chairman, I'm happy to do that. Try to do it without all the words. Thank you.
Do you have any comment, John?
Do not.
First time you will open the scope up.
Do you have a, do you have
You have the list, you have the sign sheet,
Want to call names?
want to call name up, call him and talk?
First name is George Svensson.
Mr. Chairman, Mr. Chairman?
Yes, yes, 3 minutes. Yes, 3 minutes, George.
Thank you. Hello, everyone. My name is George Bestranson. I live at 3498 Route 343 in Amenia. I do not have an outside voice. I'm sorry.
That's the mic. I'm sure you know that's the mic.
Is that the mic?
You're speaking into it. I mean, you can be heard if you're speaking.
Thank you, Sharon. This project is going to have a major influence on the agriculture in this community. I think you got to push that up to maybe the first or second issue to deal with. I'm a small farmer. I have a few goats. I can't grow the hay I need. I need a big farmer who has equipment and staff to come over and bring me hay and put it up in my loft. This is taking out at least 225 acres or whatever it was of crop row that's going to be gone. I don't get my hay from Amenia. I get it from Salt Point because we don't do that anymore here. We're building subdivisions and that type of thing. So last spring, my supplier in Salt Point, he ran out of hay. He had to import hay from Canada. And in fact, you may have noticed at the Harvest Festival, all those bales of straw, they came from Canada, not from Amenia. The other thing, I don't know, to call this an agricultural subdivision, I think is totally wrong. The covenant doesn't even allow dairy farming here in Amenia, where dairy farming was so important. I presume they also are talking about dairy goats not being allowed. And, and then the other thing is they're preserving the soils, prime soils. What are they doing? They're going to dig them up and transport them someplace else, presumably so that people can have nice, beautiful lawns in some suburb. That's how they're saving some of the soils here. What about the enforcement? How is this going to be enforced? Well, the town can sue the individual if he has a bright color on his house or if he puts a building in the wrong place. So I don't see how that's going to work. Please consider the agricultural impact that this is going to have on our community. It's going to diminish our agriculture. And I don't know if you know, but we're now in the United States, we're a net importer of food, having happened in the last couple of years. Thank you.
Next, Judy.
Mark Doyle.
Mark Doyle, 320 South Amenia Road. I'm reporting for the CAC.
That's the mic, that little thing.
I think everybody can hear me, Sharon. Thanks. So I'm going to read this through very quickly. Our first comment is on biophysical impacts. So although superficially presented as a subdivision only, the scoping does require the applicant to take into account the worst case scenario for the visual impacts. In the same line of argument, the CAC feels that eliminating or avoiding a study of water, plant, and animal species impacts or biophysical impacts would represent segmentation of the overall impacts and requests that those impacts be detailed by an accredited professional following the pattern of the visual impact analysis studies resulting from a full build-out, including the roads and ponds proposed on many of the parcels. And as a note, Dutchess Soil and Water Conservation District personnel are often quite concerned with the impact of these water bodies as they become problematic over time. Number two, viewshed protection. Clearly, there is a lot of detail here, but the CAC requests that in addition to the material listed for necessary review in the draft scoping document, that you add these two items. The Town Board Resolution number 42, adopted October 24th, 2011. It's in local law number 3 of that year, and the CAC resolution recommendations parts 2 and 3, which were directed to both the Planning Board and to the Armenia Town Board, passed on April 16th of this year, 2025. Number 3, farmland protection. While the impact of the viewshed and the community character is of critical importance, we agree, we insist that the impact on agriculture and farmland protection be included as a title in the DEIS. As a background, we refer to section A4 of the Greenway Guide, Protecting the Countryside, which emphasizes the goal of coexistence with home sites with active farmland, as distinct from simply farmland. The CAC requests that the scope of the DIS include this concept and the following issues specifically. The protection of soil characteristics is not synonymous with the protection of agricultural resources or agriculture as a whole, the active component of agriculture. The future of agricultural operations or ventures may be impacted by the very nature of the subdivisions. These impacts could include the limits on the viability of an operation due to reduced scale, limits on the operational efficiency due to reduction of access, limits on operational activities due to the requirements of the property covenant and the oversight of a homeowners association. And we'd heard in the comment before that, for example, dairy farming is prohibited, and there's a good list of other fairly normal activities that is prohibited. So in reviewing, number 4, in reviewing the alternatives in both the visual impact analysis and the use of land, the Armenia CAC requests that the alternative of a single large acreage tract under a conservation easement and benefiting from a reduction of the purchase cost due to funds generated by a purchase of development rights program be included. This form of land preservation and ownership has become a feature of important parcels of agricultural land in Dutchess County and the Harlem Valley. So this is not something that is particularly unusual. We've seen it right here in Armenia, where the model is that funds are provided by grants or private means to purchase the development rights and put the remaining acreage that is not developed into a conservation easement. Thank you, and that's the end of my comment. And I would like to leave copies for you.
Next.
Sharon Corbett.
My name is Sharon Kroger, and I'm speaking to you as secretary of, excuse me, I'm having trouble seeing. I'll get with you in a minute. Okay. I'm speaking to you tonight as secretary to the Committee to Save the View from De Laverne Hill. This statement is being written for a public scoping session held by the Armenia Planning Board under SECRA for the purpose of clarifying the documentation and concerns that must be addressed in its review of the 27-lot Keene Stud subdivision. And this hearing is held on October 22nd at 7 p.m. My name is Sharon Kroger, and I'm the secretary of the Committee to Save the View from De Laverne Hill. The co-chairs of this civic organization are Julian Strauss, former school board chair, retired veterinarian, officer of the Armenia Historical Society, and William Kroger, a former member of the planning board. This organization continues to be engaged in ongoing public education to help citizens understand the importance of this glorious viewshed, which has been captured over the years, both in our town law and its planning documents. One can find our petitions advocating protection of this viewshed throughout the town's 6 hamlets, at the food stores, in houses of worship, and other places where citizens gather. Regardless of whether one interprets the proposed Keene Stud development idea as a dignified patchwork of tiny farmlets or as a brand new network of mini mansions for well-to-do folks to use as second homes, this committee takes the classic, well-documented, and legally protected position that there should not be any kind of divisions and construction on this particular viewshed land in Amenia, period. This pure hillside and forest that is visible from the official observation point on De La Verne Hill in the famous hairpin turn, which blends into the whole Harlem Valley and distant Berkshire and Taconic Mountains, is an ongoing statement of identity for Amenia. This is confirmed at other levels of government, so that county and greenway training programs even utilize this storied view in its training materials as a prime example of how one should do rural planning that clusters development in appropriate places in order to preserve what is truly spectacular. From the human or sociological point of view, it should be understood by the planning board that our citizens are continuously involved with this viewshed and the view itself. Important rituals take place there in the hairpin turn on Route 44 above the valley. There are church services, weddings, rendezvous, and school trips. Just yesterday, and I mean this literally, yesterday, the last of the Bentons walked into the general store in Wassaic and told me that he had played the cornet at an Easter sunrise service involving 3 churches there on De La Verne Hill.
Sharon, your time's up. 3 minutes.
I got half another minute.
No.
At the recent,
Sharon. That'd be fair to everyone. No. Next.
Here, Sharon. Yeah, hi, I'm Laurence Levin, 189 Amenia Union Road, Amenia. First of all, I do concur with the planning board's identification of the 3 significant adverse impacts, and they've been cited, the visual impact, but basically I find that this plan is inconsistent with the community plans and the community character. To those, I'm not going to repeat. I think that what Mark Doyle spoke of is very important. And in my view, the most important impact that should also be added to those 3 is the impact on agriculture and farmland protection. So we've been through this visual impact problem 2 times before in the past years, one over the subdivision of Silo Ridge and also on the value to the town of the De La Verne viewshed. Looking at this map, the viewshed is no longer what we were hoping for. This is a luxury housing development that will have adverse impact on the community character, which is rural and which insists on preserving the natural beauty and agricultural heritage of Amenia. It's also going to clash with the community plan, which we've all worked on for years, as the comprehensive plan has been put in place and is being reviewed. in order to help maintain this rural character through its zoning laws and its overlay district. Here we have a obvious problem with visual overlay district. I agree with one of Mark's points is that the 154 acres, for example, is adjacent to the two Sims lots, and will totally mar this whole sort of iconic most iconic part of Amenia, which is that whole hillside, which is presently in agriculture. If anything, on those 154 acres, they might consider as an alternative placing the houses along Route 22, so that the greater part of the open space is adjacent to other agricultural lands. As for the Keen Stud lot parcel, I understand that they've tried to push back the location of the building envelopes. I could point out two things. One, in a typical conservation easement, and I've been through a couple of those these past years, the land conservation agencies usually consider a building envelope to be no more than 10% of a lot. Somewhere in this whole the scope that was put online, I read that the envelopes are 2 to 6 acres, which is a lot more than 10% of any of these lots. So I think that those envelopes should be placed more in the periphery, should be reduced to no more than 10% of their lot size. We should also keep in mind that just because a building envelope is, let's say, 10% and is placed in arrears, these are going to be luxury developments, and therefore there'll be also pools and accessory buildings around that should be considered also. Thank you.
Thank you.
You're welcome.
So I had a few things regarding the DEIS. One is that I appreciate the fact that the owner and the engineers and planners have worked on this for a very long time. I know it's a long process. I happened to be on the planning board before I joined the town board, before I was supervisor. So 4.5 years ago, this, I think, was first presented to the planning board. And at that time, it was noted that that the rural siting guidelines of Dutchess County and of the Greenway should be what was first looked at in terms of moving the buildings towards the hedgerows and the tree line. And it probably would have saved a lot of time over those 5 years if they had just done that then, instead of waiting such a long time to do something that should be pretty obvious. This view is iconic for Amenia. It says so multiple times in the comprehensive plan. The view is what gave Amenia the name of Gateway to the Berkshires. FDR used to drive over here in his car that he operated with his hands from Hyde Park, have picnics at the top of that hill. Doing this will really ruin that effect. I mean, will ruin the thing that is probably most lovely in all of Amenia. The idea that the unobstructed agricultural land now is going to be broken up into little fiefdoms is really, to my mind, kind of tragic. It seems to me there's no reason that the house lots could be separated from, I mean, other than getting an ag exemption, the house lots could, it seems to me, could be easily separated from a preserved agricultural zone that would hugely lessen the impact of all this on the view from Delaware. And I also am especially sensitive to this because I was on the zoning board when the silo development was approved, and I know that ultimately the planning board, didn't pay any attention to what the zoning board said, but more than that, failed horribly to actually enforce the zoning that's very carefully written for Amenia, that said things like we shouldn't be building on steep slopes,
that the architecture should be based on architecture of Dutchess County. I could go on and on and on, but basically the planning board just sort of rolled over on that and didn't protect the town. So I hope that the planning board will be more conscientious this time.
That's all.
Anybody else?
Anyone else like to speak? Go ahead, sir.
Hello, my name is George Sanchez. I've lived here since
I'm sorry, your name again?
George Sanchez. Sanchez, S-A-N-C-H-E-Z, 496 Old Route 22. So I've lived in this town since 1996, and most of you don't know me. The ones that do legally kind of get to know me. So the thing that struck me, this is conversation about DEIS, the studies, when you put up the two images of this development and Silo Ridge. That was quite striking to me, because it felt like I don't live in Armenia, I live in a development that could be in Poughkeepsie someplace. Some days, when I'm having a bad day, and I'm coming back from the gas station in Cumberland, instead of making a right at the rail trail to go home, I take that drive up and over the hill. That is a spectacular view. We all know that view. It warms my heart and my soul. It doesn't matter how you hide it. It doesn't matter how far back you put it. That view will be gone forever. And I know this is preliminary and we have all these steps, but I want you to step back and think about what we saw today. The two images of those two developments. Imagine driving on Old Route 22. You already see Silo Ridge coming into town. Now you'll see another development on the right side. So that's all I want to say. Thank you.
Anyone else?
Yeah, so couple things. There were some folks who had written statements. Those should be provided to Judy, who's the keeper of the written record. And all that information will be provided in full to the planning board and to the applicant. Again, even if you didn't speak tonight, the public comment period, the opportunity for written public comment is not over. That will be extended until next Wednesday. So I would encourage anyone, if you want to take time, look at the draft scope that's on the planning board's website, look at the application materials on the planning board's website, and please provide any written comments that you may have. And then finally, again, to just reiterate from earlier, once the draft environmental impact statement is done, there will be, and the board determines it to be complete and good enough for public review. That will be the subject of a public hearing both on the environmental impact statement and also on the subdivision itself. So that notice, of course, will be provided at that point in time. That's all I have.
We have no, okay. That being said, the next step is.
The next step will be for the public comments to complete, coming in by next Wednesday. Then the applicant will have the opportunity to respond to those based on, they have a stenographic record that's being provided or done as well. And then once the planning board has those responses and reviewed all the public comments, the planning board will finalize the draft scope, and the goal is to do that at the November 12th meeting. And after that, the applicant will go and do its work in terms of developing a draft environmental impact statement.
Any comments from the board?
Yeah, I just need a clarification. What exactly is the residential agricultural lot?
Okay, that will make sure that's provided.
Any comment from the board? There's no other comments from the board. I want to say a couple things. Is your wife depends on it. You change your clock, change your battery, your smoke detectors coming up. I say this every meeting, to get this to your heads, everybody. Make sure you put your back in your smoke detectors. Very important. Everybody's really depend on this. All about life safety. I'm a firefighter for more than 40-some years. Volunteer for this community, so remember that. Change your battery, your smoke detectors. Okay, if any of that being said, I guess we need a motion for adjournment then. Move here. You second? All in favor? Aye. And I have a good evening.